Good morning, ladies and gentlemen. It's a real privilege to be here. And the reason why I use this rather abused term is that you will see that there is a special interest in your gathering here, but I leave this for the presentation. Now, I recall a conference about 6 or 7 years ago that was held at the court at that time. It was on freedom of expression, where distinguished experts claimed that the standards of the court in matters of speech protection were in decay, partly because of deferentialism to the panic resulting from terrorism. Leroy contre la France was and is still mentioned as the paradigmatic example. Today, in an age when backlash is the buzzword, I would not be surprised to hear voices murmuring, at best, that the court's protection of freedom of expression is less robust than even 10 years ago. However, the problem lies elsewhere, not with the court, at least to a considerable extent. It concerns the changing public attitudes towards freedom of expression in Europe and globally. This shift is also intimately related to the prevailing attitude regarding the possibility and scope of supranational judicial protection of human rights in general. I would like first to refer to the substantive challenge freedom of expression is facing. A new logic of mass communication has emerged. Citizens are no longer passive recipients of news and views developed by journalists or other opinion makers. With the coming of the Internet and social media, there was a rather realistic hope that the production and management of information would be replaced with a decentralized system where individuals would become more active partners in generating information. It was hoped that all this would enhance democracy. Undeniably, there are positive developments in this respect, but pain is the sister of progress. Instead of creating a common space for democratic deliberation, the Internet and social media enabled fragmentation and segmentation. Discourse is limited to occur within self-selecting groups, and there are tendencies of isolation. Views are more and more extreme and less responsive to external arguments and facts, resulting in polarization around what is another buzzword today, alternative facts. The new possibilities of personal interaction through new media have liberating effects, but the liberation includes the waking up of otherwise repressed negative moral and emotional characteristics of human beings. Communication also means freedom to fake news, a freedom enjoyed and abused by individuals, political movements, and governments. Today, more and more people ask, what is so special about speech, which is, after all, just one of many human interactions? Free speech was held to be sacred. This sacred nature is questioned today. Even if the values of free speech are still relevant and justifiable, the background conditions of free exchange of ideas seems to be more and more absent in many respects. Citizens live in self-imposed selective worlds of alternative truth, where their rational capacities are paralyzed by externally reinforced wishful thinking. Now, if that is the case, what are the grounds and justifications for free speech? Political communication is, of course, about lying, a competition to find the most attractive alternative truths. In these circumstances, are democratic states not called to intervene to restore political communication by setting the conditions of communication right, by limiting potentially harmful expression and lie? Maybe. But how to trust the very democratic process with this task? After all, this very process is expressing the very bias that concerned people would like to rectify. What if all the calls to responsible speech and responsible journalism are but another attempt to determine governmentally or politically what is right or wrong, and to impose a new political correctness upon dissent that is labelled false and fake. Today, electors are influenced not just by unrealistic promises, but by statements of facts which are simply and plainly untrue. Nevertheless, they are attractive as they satisfy the expectations of identity politics. Should not the government interfere and rectify? But the reliance on lies is not the cause, but the consequence of that very identity politics. So if identity politics is the root problem, how can one hope that governmental speech regulation will be the remedy? Of course, there is no social value in false statements of fact. Even the notoriously speech-friendly Supreme Court of the United States recognizes that. Look at Gertz versus Robert Welch. False statements mislead the audience and, at least to some extent, deter the speaker to make true statements, since their power is unfairly limited. But is this a good enough reason to punish false statements in politics with the force of law? Not necessarily. There are at least interesting arguments in favor of allowing some level of error in speech. Otherwise, the search for truth will suffer. Moreover, the difference between opinion and fact is not clear-cut, and opinions are powerful exactly because they are often fact-related, where facts are murky. To call a prime minister corrupt can be related to facts, but may still be factually wrong in terms of criminal law. In a simplistic logic of regulation, fake information is to be oppressed, and states today would like to outsource this policy, imposing duties of censorship on intermediaries. Those who would like to curtail speech to improve communication must answer an important legal question. For example, what is the appropriate level of responsibility, and also who is to be held responsible? There will be different answers to these questions in different democracies. And in case one would like to legislate against alternative truths in politics, the standard problem arises. Who will determine what is true and how it will be determined? But you came here to discuss, under the Convention, what kind of reaction to expect and generate to the new communication paradigm. Is the Court going to allow governments to hold people responsible for honestly held but apparently untrue statements of fact? Is it going to accept or even require punishment for what is held in some jurisdictions to be harassment in the social media? Would it be permissible under the Convention to ban foreign-sponsored broadcasting that seems to report on alternative truths systematically? What kind of protection may citizens expect where the alternative truth comes from government, including their own government and government-sponsored media? The Court's case law of the last 10 years offers interesting clues. In search of an answer, some of the colleagues present here would read the tea leaves of Pentikainen, which introduced the concept of responsible journalism, although the cases referred to, like Bladet Tromsø, dealt with, I quote, good faith to provide accurate and reliable information in accordance with the ethics of journalism. This change would imply that, contrary to Bladet Tromsø and progeny, where, as a rule, newspapers in their reporting on statements of others had no absolute duty to verify the truth of a critical factual statement, such duty would be found acceptable or even necessary. Now, combined with the emerging idea of intermediary liability, that is to say, the liability of intermediary service providers, this idea transferred from journalism to all speakers would facilitate a government-led fight against false, private, and public statements of fact. This is a genuine possibility. But in my view, the developments which are relevant for the Court's future position are not intimately related to the substantive understanding of the applicable free speech principles, although some of the judgments reflect the victory of what I consider to be the cult of narcissistic personality that is dressed up in the best ball gown of dignity. The new developments, once again, may not occur at all under the spell of responsibilities and duties clause of paragraph 2, article 10. It is more likely that the court's position will not be determined on grounds of freedom of expression considerations at all. It depends already on the self-perception of the court, its understanding of its own role. Likewise, in the future, it will be decisive how the court, under the pressure or encouragement of the member states, will understand the role of the court in human rights adjudication. Let me illustrate how competence issues, very often expressed in terms of margin of appreciation and subsidiarity, determine substantive law. In a case against the United Kingdom concerning Naomi Campbell, MGN, less known under that official name, so the Naomi Campbell case, the court embarked on the rereading of Article 10, paragraph 2. It gave equal weight to reputation rights and freedom of expression. Of course, the Convention recognizes the rights of others, in particular the right to protect reputation as a ground for rights restriction. Such an interference to protect reputation has been considered as falling under standard proportionality analysis, where restriction is the exception. In MGN, however, and it was taken up in Grand Chamber cases, so in MGN, reputation was considered a matter of right to private life, and contrary to the text of the Convention, the case was construed as a matter of conflict between two conventional rights where balancing applies instead of proportionality analysis. Hence, subsidiarity and a lower level of scrutiny prevailed to the detriment of freedom of expression and, of course, to the pleasure of those who believe that privacy and dignity are to be protected when it comes to defamation. This approach reflects a new hierarchy of values compared to earlier years, perhaps more in tune with narcissistic times. Another development that can favor a new restrictive or, for others, a better balanced regulation has emerged in two more cases concerning, again, the United Kingdom. Animal Defenders was, strictly speaking, a proportionality case concerning political speech, speech on matters of public interest. A majority of 9 out of 17 held the relevance of parliamentary proceedings with extensive debate when conducting the proportionality analysis of a blanket ban on political speech. The blanket ban in that case was anointed by parliamentary democracy. Later on, in RMT versus the United Kingdom, an Article 11 case was relying on this approach. One of the elements in that case that led the court to disregard the international law as developed by ILO was national democracy. And this right to secondary strike case had a very interesting twist. Here, democratic consensus within a country in support of a restriction was considered a matter that results in a wide margin of appreciation. So once again, where there is a right, national democracy is decisive for the court. And we are talking about a right. In this right, in this case, more importantly, and contrary to many, many judgments which state the opposite, the court observed that regardless of proportionality analysis, the question is, I quote, is rather whether, in adopting the general measure, the legislature acted within the margin of appreciation afforded to it. This kind of localism recalls the court's emerging case law, which claims respect to deeply held national moral beliefs and national sensitivities, even in the presence of an overwhelming European consensus pointing to the existence of a right. Of course, national sensitivities and national democratic consensus are not particularly promising to universal and regional and certainly supranational human rights, which are recognized by the Convention. After all, this Human Rights Court was established to promote greater unity among member states through a common understanding, I quote, and further development of human rights, end of quotation from the preamble. Now, part of these developments can be explained by changes in judicial attitudes towards judicial deference. As late as 2012, Richard Posner could write about the fall of judicial self-restraint. Today, under the pressure of anti-elitism that celebrates the alleged reinvigoration of popular democracy, we observe the rebirth of judicial self-restraint. An international court, especially if isolated within an international bureaucracy, under the pressure of increasingly isolationist and sovereignty-driven governments, and without public support, will easily conclude that it has a limited role in this world and favor the primacy of national cultural differences. Let me quote again from Animal Defenders. It is for each state to mold its own democratic vision. There is, of course, another possibility for judges, although I fully understand the reasonableness of the previous approach, where the assumption is that European public abandons human rights and defenders of human rights. So again, nevertheless, there is another possibility for judges in a world that seems to be little interested in the values that animate the Convention and that are foundational to the very democracies whose democratic process seems to be out of sync with said values. Here, the role of the judge is that of the prophet who reminds her errant people of the higher values, even if those are disregarded. But is there still place for legal prophets who are aliens in national, populist and popular democracies? This is a freedom of expression conference, and there can be only an indirect answer to this question. But even if this were the proper role for the judge in times of fundamental challenge, the prophet should know what she is defending and what for. And this takes us back to my fundamental question: how to justify speech in a communication sphere where communication and communicators apparently do not satisfy fundamental expectations of rational discourse. The judge prophet cannot find the answer. It is the free speech community that shall raise its eyes and critical voice from the grittinity of specific cases. It is you. Thanks for your attention. Good night and good luck.